This is my approach and question, how to represent to go to the court or to stand to the court, and how to compensate damages to nature. Well, first of all, we need to be more clear on the question of damages to nature. There is one approach which is a mixed approach. That means about damages to human beings or personal or physical persons and nature, for instance, through pollution. And there is the other approach, which is the pure ecological arm. I will emphasize on this one. If I can, yeah. On this one, that means only damages to the nature itself, for instance, a population of birds, or a national park, or a forest. Well, I will rely upon several texts. That's my aspect, or my approach, to be very precise on what's existing, or on existing legal provisions. Well, I won't go through all of them, just to show you that there are different approaches of the question. And, well, the final question will be under US common law, how to represent nature in the front of the courts. But as you see, through, let's say, international convention, like Lugano Convention, or EU law, or even domestic law as French civil law, even UAE, there is always an attempt to represent nature. Just to sum up, we can represent nature to the court through a body from the state or agency, or let's say association, foundations, or non-governmental associations, organizations. Well, for instance, at the present time, we just have a few definitions of what is nature or what is environment. So, well, you have very comprehensive definitions like for instance, the Lugano Convention, natural resources, properties, etc. Some definitions are mixing nature and human properties. Others are far more comprehensive. For instance, no, that's not the one. Yeah. For instance, here in the UAE, we have a very comprehensive approach to nature. You might have the natural elements, for instance, animals, plants, but also humans. So there is a mixed approach, and even industries or some, let's say, premises or human premises, which is a very broad approach to nature. We won't focus on this one due to the fact that we are more focused on damage to nature itself, like population of birds. I just want to introduce a very short back in the ages, or let's say from the Dark Ages or till the 18th century, to show you that representation of birds or animals is not a new question. We had in Europe questions of, let's say, ecclesiastic or church cases when a population of, let's say, animals or insects caused damages to the human, for instance, vineyards or crops. There was courts or trials against the animals, but what is interesting now is how these animals were represented. They had the procurator, and they had a lawyer, and there was a real trial. That means the question of representation to nature is not a new question. It's just on the reverse. Nowadays, it's how to compensate harm done to nature. In the, let's say, Dark Ages until 18th century, in these church trials, it was more damage caused by animals. Well, just a real short stop at Lugano Convention. As we see, association, foundation is the first way to represent nature. And also, if we go through, for instance, the new French Civil Code, this is more comprehensive. We have an agency, for instance. An agency might be, this office is an agency who can represent the interest of nature. And if we go the more comprehensive text, even it's not very efficient, which is a European directive, again, you might have the state, association, foundation, or non-governmental organization. I will skip. For instance, here in the domestic law, it's an agency which is in charge to represent nature or the interest of nature, no association, no non-governmental organization. If we are coming to the question of representation of natures in case of damage to US common law, it's interesting because it's a question of standing to the court. How or who can stand to the court? And as we see, even though we have, let's say, associations or foundation, organization dedicated to protecting the nature, it's always mandatory to show that human beings or physical person have been aggrieved by the pollution on the general principle polluter paid. But there is a hence or obstacle in the US common law about the question that in the meantime of nature, purely nature, human physical person have to be aggrieved to bring the case to the court. Well, we'll move now to the question of compensation, not anymore representation or standing to the court. The question is how to compensate the damages. Well, generally speaking, if we are working on the basis of liability or tort law, all the damages should be compensated, but here we'll need to have an overview, a short overview of what kind of damages. Well, generally speaking, the purpose is to repair or to compensate in kind. That means really the damages caused to the, for instance, the national forest or the park or the population of birds. So this is the main part of the question. And for instance, here in the UAE federal law, we see that the person liable or the company who aggrieved nature or a park or some populations has to pay the costs and remove the damages. Again, the most comprehensive and interesting text probably, or legal approach, is the European directive, again, which is not very efficient, but very detailed on different steps of remediation to damages to nature. So there are the remedial measures, which is the idea to reparation in kind, then the costs, of course, and at the end, if it's not possible to repair in kind, then there is a question of compensation. Well, so if we want to sum up this very brief overview, to represent nature in the courts, it's association, foundation, or let's say non-governmental association, organization, or an agency, or the state at the present time. The question of compensation is, well, quite clearly mentioned in these European directives, or always the same idea arises. That means compensation in kind as much as possible, and then compensation through the agencies, organization, etc., by just allowing damages. Well, just to open the debate, but not here, I will give the floor to my colleagues. We need to know, we all know that there are some, let's say, animal studies which are, let's say, on the track saying that we need to provide to nature or animals a kind of citizenship or a kind of personality approach in order to pursue themselves to nature. This is, well, the question is then if we want, what is the best way not to do to man what man does to nature, but it's a philosophical approach. At the present time, on the legal approach, we are much more on representation, not the nature itself going to the court. I give the floor to my colleague about the approach through the treaties.
Thank you. Thank you very much. So basically, my presentation is going to be shaped around three things. First of all, state's responsibility, which is somehow showing in there. The second is the treaties and the way those treaties are structured and the way they are sometimes not very well structured. Then basically the role that the international courts can play. And finally, maybe a little point about international relations which might have a certain impact on how those treaties are effective or not really effective to a certain extent. So first of all, obviously, climate change and those various international, I would say, problems that had been at least considered for the last years, have an impact on how states are going to get themselves into that problem and to get themselves basically in the front line to that sort of issues. Doesn't mean that those issues through various conventions have not had any impact over the years, but still the states have a major role to play because the states shape basically treaties, they shape conventions, and they're very much at the front line of such issues. So as long as the states are not very much conscious about the fact that they need to do something, there's not much that has been done or that can be done, basically. And as we speak, today, obviously, this is an example for, and the other COPs obviously also, are examples of how states get involved in such issues, but still there's much to come, I guess, and there's still much to be done. So if we go through treaties, it doesn't mean that we have no effectiveness. What it does mean is that we have certain treaties very much specific about certain issues that are very well built and very well functioning. Still, we don't have anything which is a global approach of whatever is damage to nature or damage induced by, I would say, actions, and even less responsibilities of states in such matters. So what does this mean? It means basically that there's still much room for improvement. And for example, as it's going to be shown afterwards in the last slide, we have also lack of definitions, and specifically those infringements that could be seen basically that are very much important to take into consideration. So that is the first part. The second part is, if we move away from those treaties per se, is that we have many issues that are linked to also implementations of, I would say, actions and still initiatives that appear through treaties, but still are not very much made effective, because at a certain point, courts are either not really shaped to put those into action, or, on the other hand, not even taken initiatives to secure those treaties in a way they should be. So that is the second part. So it doesn't mean that, for example, the ICJ doesn't take any action or doesn't condemn, for example, some sort of actions to make them effective. That's basically the second point I'm raising, that there is nothing which can be done if you have regulations on one side and you don't have any courts to implement them. So obviously, state initiative is very much important. Treaties as they are shaped are very much important. And obviously also the way they get implemented afterwards, either in or through courts that are designed to implement certain conventions, like ITLOS, for example, or some others, but still they are very much at the core of whatever could be considered as effective in a certain way. Here you have a few examples of some definitions and some precisions, basically, that or even responsibilities that have been designed through cases. So that is the second point. The third point is basically at, I would say, the time that all this takes. And if you consider that at any, I would say, any international convention, any international treaty takes much time to be put into place, you are also talking about shifting and changing international relations. So that means, and that's maybe a point which is either as important or as, I would say, crucial as some others, the fact that changing international relations is something which is basically an ongoing process, a never-ending process. You have, at a certain way, I would say, treaties that emerge in time that are not very much compliant with the changing international relations we have been talking about. So there are treaties also that made a little bit, I would say, I wouldn't say useless, but still a little bit less effective over time, because also of changing international, I would say, balance of power, or things that are very much linked to emerging new powers, and also to climate change. if, for example, we take one treaty, which is the treaty on the Antarctic, for example, we know and we see today that as those treaties were, I would say, not a big issue economically seen or even through international relations, those treaties, they get a kind of a crucial importance today, and the fact or the way they're going to be implemented and the way they're going to evolve are very much linked also to international interest in the poles, and those interests are very much raised because also of changing climate. Basically, if there is a conclusion to be drawn there, it's first of all, states needs to take action, which is something kind of easy maybe to say, not that easy to do. The second is to have treaties that have more, I would say, broader definitions of what climate, I would say, climate-induced actions or infringements to climate and damages to nature to be done. Then you need to have also tribunals or courts that take into consideration those different issues, having also a deterring effect basically also on whoever is maybe in the position of infringing or causing damage to nature. And that means also that if you have condemnations, for example, that are not very much high in amounts of money, if we want to say this way, you are not having that deterring effect, basically. If you take one example of the ICJ, for example, which the case is Costa Rica against Venezuela, 2018, for example, the amount that has been granted compared to the amount that has been asked, basically, was very low. So there is no deterring effect, basically, to such a thing. So yeah, and at the end, obviously, the time which goes on is very much important, because it's not very much compliant, if we want to say this, at the very end, to well, from the beginning, where international relations might have looked a certain way, or a balance of power have been looking a certain way, and the end, where obviously things might have changed. And the way it changes is also what has basically a very big impact on the effectiveness of the treaty. Thank you very much.
Good afternoon to everyone. I'll follow up as per what has been said with a different proposal maybe. It might be natural when we talk about repairing damage to nature to think firstly about environmental law, international environmental law or domestic environmental law. My invitation, however, today is to discuss reparation of environmental damages, damages to nature, outside the realm of environmental law. And I'll focus mostly on one specific aspect of international law, which is called international investment law. So why international investment law? And firstly, what is international investment law for those who are not used to this field of public international law? International investment law is basically the law field which offers a legal protection to private investors and private companies, multinational companies mainly. So the protection offered to these companies in international investment law is a very generous protection. So it is basically a law field which specializes, which focus on protecting companies. So why is this law field relevant in order to discuss environmental questions? Because it was not created, born and raised to deal with such non-economic issues. For two main reasons. Firstly, because many of these companies which are potentially protected by international investment law, if we take only the first 20 main polluters, globally speaking, these companies are protected by international investment law, which means that companies which potentially cause damage to the environment, they are protected by international investment law. And secondly, because this law field, international investment law, is more and more starting to incorporate norms of environmental protection. So these are the two main reasons which justify why international investment law is an appropriate law field, not to make revolutions, but to discuss the issue of reparation to damage. And the main problem, the main conundrum which I want to address here today is considering that international investment law focuses on protecting multinational companies and investors, what are the legal instruments which can be mobilized within this specific law field in order to effectively manage damages to nature or to the environment more specifically? To answer to this question, I have two main arguments, so two main instruments, which are the first one at least is very technical, a procedural instrument which is complemented by a material one. The procedural instrument, which I shall explain in a few moments, is called counterclaims. So it is possible to repair environmental damages in international investment law by the means of counterclaims. However, this shall be my second point, the effectiveness of counterclaims in matters of repairing environmental damages depends upon the existence of specific environmental norms, more especially of domestic environmental norms. So turning to my first point regarding counterclaims. In international investment law, as I mentioned, private companies and investors have a wide range of legal protection. For instance, a company which considers that a state has adopted an environmental measure which has such an impact on its day-to-day activities that it pushes it out of the market, this company can sue its host state. It will be a foreign company suing its host state for something which is called indirect expropriation. It means that an environmental measure which is adopted by the state has such an impact on the company that it is equivalent, it is tantamount to what is known as an indirect expropriation. So if this happens, if for whatever reason a private investor or company considers that the host state has violated the treaty, the company can sue the host state before an arbitral tribunal. So it is here that the main important procedural part comes into action, because the state has the possibility of doing what we call a counterclaim. What is a counterclaim? To explain in simple terms, it is a claim for relief whereby, in a similar case, but for a different legal question, the defendant becomes the claimant and the claimant becomes the defendant. So it is a legal instrument which exists in the civil law of many countries and also in international law, and for us now in international investment law, which main means of dispute settlement is arbitration, which means that if the investor or the company starts an arbitration against a state, if this investor is acting with dirty hands, for example, if this investor does not have a corporate social and environmental responsibility, the state can engage into a counterclaim against the company for the same case, but for a different legal question. So counterclaims have succeeded in at least two cases. That's why I said it is not a revolution. However, it is still a small step forward, right? So in two cases against Ecuador, the first one is called Burlington against Ecuador, and the second one, Perenco against Ecuador. The state started a counterclaim against the investor, Burlington in the first case and Perenco in the second case, and won. The counterclaim was successful. So in the first one, in the Burlington case, the arbitral tribunal acting in the counterclaim condemned the investor to pay more or less a value of $35 million to the state. And in the second case, the value was about $54 million of environmental damages, which means that in a very specific law field, which traditionally protects investors, multinationals, there is the small possibility of engaging the environmental liability of multinational companies and of private investors, and of winning, as it happened in those two cases. However, there are some limits, two limits at least. The first one is that a counterclaim is possible only if there is a main claim. So it is not a stand-alone claim. So we need a first claim, we need an initial arbitration in order to proceed with a counterclaim. So obviously this is a limit. within the system. And the second one, the counterclaim is successful depending upon the clarity of the environmental obligation incumbent upon the investor or the company, which brings me to my second part. I think I stand this way because I'm not seeing the screen. Here neither, actually. So, the second point is the effectiveness of the counterclaim depends upon the clarity of the environmental norms. So, as international investment law is related to protecting investors, obviously, and initially, there were no norms, no principles, no toolkit regarding environmental protection. However, little by little, because of cases which relate to what I mentioned earlier, the right to regulate the environment of the state being systematically questioned before arbitral tribunals, states have started to incorporate within one of the main sources of international investment law, which is the International Investment Treaty. States have started to incorporate environmental norms within these treaties. Two sets of norms. The first one regards the right to regulate the environment. So there is a tendency whereby states or organizations like the European Union have started to incorporate their own right to regulate the environment within the treaty, which means that the investor cannot question this right of the state. However, this does not lead us to repairing damages because it only preserves the regulatory environmental right of the state. Okay, so I mentioned the European Union. The last agreement on investment protection, which Brazil signed with the United Arab Emirates, for example, also contains a specific provision on this right to regulate the environment. The second set of provision regards directly the private investors and companies. There are provisions on corporate social responsibility. This same agreement signed between the United Arab Emirates and Brazil on the facilitation of investment contains a very long and detailed provision on corporate social responsibility, which includes references to environmental protection, and which give duties, direct duties, addressed to investors and companies. However, there is a limit to these provisions. This limit's twofold. Firstly, very often, these provisions on corporate social responsibility are not binding. They are not binding upon the investor or the company. Secondly, as it happens mostly in the Brazilian model, in the Brazilian investment agreements, these provisions are not arbitrable, which means that they cannot be the object of an arbitration. So it seems that the provision appears to be a dead letter. So for this reason, and this leads me to my last point, it is of utmost importance for the state to consolidate their domestic law because they have a higher margin of appreciation to do so. In those two cases I mentioned, Burlington versus Ecuador and Perenco versus Ecuador, the counterclaim was successful only because of the existence of clear environmental duties applied to private parties, private entities, within the Ecuadorian domestic legal system, especially the Ecuadorian constitution, which provides for duties to public or private entities, environmental duties, I mean, in this sense. So the arbitral tribunal, which is an international tribunal, referred to the domestic law in order to engage the environmental responsibility of the private party and to condemn the party to pay for environmental damages to the state. So those two cases were successful only because of the existence of such norms. In other cases, the arbitral tribunals have acknowledged the possibility of a counterclaim. They considered that they had the competence to hear a counterclaim. However, the counterclaim was not successful because of the absence of environmental duties applied to investors and companies, or because of very unclear norms related to corporate environmental duties. Some states have already started to consolidate their investment laws and investment codes or environmental law, whereby they include clearly environmental duties, a set of environmental duties which apply directly to private parties. So as a takeaway in 3 points, as a conclusion in 3 points, which will leave us some space for the debate afterwards. Firstly, it is possible to discuss environmental law outside the realm of environmental damages outside the realm of environmental law. We can do so in human rights law, and as I mentioned, in a very unexpected law field, which is the law field which protects investors, which cause damages to nature sometimes. Secondly, it is possible not only to discuss environmental law within international investment law, but to do it with concrete results. As I mentioned, those two counterclaims were successful. And it is very difficult, as you might know, to condemn a multinational company at the international level before an arbitral tribunal or before whatsoever tribunal which would have competence to do so for environmental damages, let alone before domestic courts. So that's why it is a small step, but it is a very concrete step which led to effective results. My last point is that even though environmental law is not the main focus of international investment law, it appears as a byproduct, and as a byproduct which has led to concrete results, as I hope I explained. Okay, so thank you for your kind attention. Thank you. We finish a bit earlier, but this leaves us some space for the debate eventually. Yes.
We have time for questions now for the colleagues or any one of yours three. Yes.
I found the Brazilian presentation particularly interesting because the issues that are playing today are a repeat in many respects of what happened in '86. As you will know, Brazil at that point in time had about $5 billion in debt to the international banks, and Citibank at that point in time accepted environmental responsibility by doing, with Mr. Lovejoy of the World Wildlife Fund, a transaction to convert debt, in this particular case in Bolivia, to under a debt for nature transaction, which has subsequently developed into a major field, and certainly now with the new Brazilian initiative is hoped to grow to a much bigger market. Is there any chance of, given our understanding of Scope 3 obligations, the fact that, you know, if you make $5 billion of loans, of which a significant portion is odious debt, which again is a subject that hasn't been touched but comes very much under the investment laws, is there a possibility at this point in time to, at least in the court of public opinion, to create a moral obligation that banks which have caused so many damages that they contribute to the loss and damage fund more than the 17 million that is being contributed by the United States government?
Yes, there is. I'll focus on this last point. There already exists a moral obligation which have been incorporated in non-binding texts like the principles of Ecuador, as they are known. However, on a more legal and binding basis, there are cases in which banks have been condemned. There's one interesting case regarding a French bank, BNP Paribas, in French courts right now for damages caused in Brazil, environmental damages caused in Brazil. So the case was brought to France because of the existence of a very interesting statute law in France, which is the law on the due diligence of companies, which means that Brazilian victims have sued the French company in France because of damages done in Brazil. And in the very local context in Brazil, there are many cases also pending against financial institutions. So I would say, apart from the moral aspects, there are also legal concrete measures which are being adopted.
I would add that it's necessary to show that the financial institution was aware about what's going on, what is the project, the reasons of the projects, and what will be the results of the project. If not, if they are just financing, let's say, with a shadow screen, then it won't be possible to sue.
Well, I can tell you in '82, Citibank could write Brazilian laws, could force Brazil to waive sovereign immunity. Some of us traveled to the Pantanal and observed in the Amazon directly what was going on. So, and of course, the World Wildlife Fund under with Lovejoy, was very much in '84 the leader in this whole area. So there was no confusion as to that. We knew what was going on.
Is the conflict of interest between the states, the industrial companies, and the victims. As a result, we've got quite a few cases still unresolved, going back quite a few times. The first one that comes to my mind is the Aberfan disaster in South Wales, where over 200 children were killed, and the National Coal Board in the UK abandoned the responsibility. They say nothing to do with them. They created the problem. Secondly, the second incident that comes to mind is Bhopal. Even to this day, that is unresolved. And the last one is the Vale incident in Brazil. All those cases remain unresolved because, first of all, the different laws are contradictory and the different states' priorities are different. Would you like to comment on that?
Thank you. As the links that exist, or as I would say, basically the capacity of some international, multinational companies to influence various types of states, not even only, I would say, weak states, even in the way we could think of those, is very much important. And that's why I was mentioning also the fact that states have responsibility. They have also responsibility to be independent and sovereign in a very, let's say, large way of taking a look at what sovereignty would represent, not only because they have like strong institutions and domestically they are very much viable. That's not the case. You need to be sovereign also vis-a-vis whatever can influence your own domestic policies, and that is very much, I mean, the example of Bhopal you was citing is the one that came to my mind was, because it's a very interesting case and still ongoing case. With, I would say, consequences that are still unsolved and would never be until a few generations to come. And that is very interesting example you're citing. Thank you very much for that.
My question is for Professor Nitish. So you had spoken about the the possibility of using investment arbitration to deal with environmental issues. But I wanted to know your opinion on the desirability of doing that, because a lot of the states that have to deal with the environmental fallouts of foreign investors are your developing countries. And as we know, the costs of investment arbitration are significant. So significant that a lot of the times you don't see host states being willing to sort of start a counterclaim just because of that cost aspect. So is litigation not the better alternative to investor-state arbitration for dealing with these issues?
Yeah. Litigation is never the best alternative. We go to litigation only when we have no other choices. So in the case of counterclaims, it is one of the means within the whole set of toolkit which is available to states if ever the others don't work. So personally, when it comes to environmental damage, prevention is always the best option. So there is a lack of preventive measures of regulation on due diligence of companies. I'm not focusing on states here, but of companies regarding their due diligence. So, which means that in my view, the responsibility should be related to the lack of due diligence. However, given that there is a lacune in this field right now, counterclaims have proved to be an effective measure. So I'm not saying that I'm necessarily favorable to counterclaims. I'm just saying that it worked in two cases. Yep.
Thank you.
In addition, perhaps we might say that legal aspects within policy orders, when it's possible for a state, even a developing country, to implement policy orders are legal policy orders, then it's not arbitrable. So perhaps it's a way to manage both arbitration. You mentioned it's too expensive, and if you have to apply, let's say, more policy order statutes or legal approach, and with perhaps criminal approach to damages to nature, could be a way to waive the question of arbitration.
Hi, my name is Beatriz. I'm from Brazil. And my question is, with climate finance flows expanding and with this finance having certain criteria when it comes to green indicators and how that money is going to be spent, I'm wondering how the accountability will happen in terms of that finance is actually going to achieve the ends to which it is destined, such as emissions reductions, or even how are you seeing the incorporation of justice and equity criteria in those green investments, and if that accountability could be achieved by which means? Would it be maybe litigation, or how could, for instance, global south countries address the issues that are being created by companies that come mainly from global north, and there is this distance and different, of course, legislations. So is there maybe, what are the mechanisms that you think would be appropriate to enhance this accountability and promote a more coherent green development? Thank you.
On my view, well, nowadays the question of damages is if we go within European law, that means for the 27 member states, you can suffer damages, for instance, in Brazil or South America, and sue, of course, a northern company, but you can sue it in Brazil because this is the place of the damages, but you can also sue in Europe, within Europe, because this is the place of where is the company is incorporated. So you have, for the aggrieved party, it's possible to settle in his own country, and so that's one part of the question, or the answer. That means not to be shy to sue, because you have the choice to sue where the damages are suffered, or where the aggrieved, let's say, the tort doer is incorporated. Is a part of the question. You want to answer something?
No, I thought you were willing to ask a question, but I don't know if there's still time left.
Thank you. I am from esgmina.com. Just in terms of, I can see that the discussion and all that about Brazil, about Europe and the United States. As you know, we are in UAE, that's COP28, and the UAE leadership is very keen to develop their legal framework for across the board, and we're seeing the Prosecutor General going as harsh as possible directly, bypassing everything. Is basically, are you working on anything in terms of developing the legislation in the UAE or in the GCC?
Thank you. The problem with international law is always that there needs to be a goodwill, and that every kind of country or state has to, at a certain point, implement things for its own, let's say, domestic affairs, and then obviously try to promote those initiatives or try to spread basically those various tool cases maybe that they can offer to the world. So there's a way of implementing things, and there's a way of promoting things. And I guess raising consciousness is one of the, I would say, the first step. Trying to promote those things more like in a broader scope is the second step, and we're still like in between, I guess.
Just to add, if my colleague wants to withdraw a little bit, yeah, a part of the answer is that's the statute we have in 1999 in the UAE federal law. That means protection and development of the environment, which is a very comprehensive statute, and which provides many answers on this question. Very, let's say, contemporary approach to this. We can go on this. First of all, who is going to sue, agency to assess the questions, and how to compensate. So, of course, UAE is completely involved in this question, and the sources of these statutes is really worldwide approach. think we'll end with this. We are here a worldwide approach on all these questions. Thank you for the assistance and the questions.
Dear guests, thank you for joining us for the program for People and Planet at the Expo City Dubai Pavilion at COP28. We hope that this has been a valuable opportunity for you to share, learn, and work together in service of people and planet. Today's programming has now finished. However, please scan the QR code on the pavilion screens to learn more about our extensive series of programs and events during COP28 and beyond. Thank you and see you again. ضيوفنا الأعزاء، شكراً لمشاركتكم في برنامج الإنسان وكوكب الأرض بجناح مدينة إكسبو دبي في مؤتمر الأطراف COP28. نرجو أن تكونوا قد وجدتم جلسات اليوم فرصاً للتعلم ومشاركة الأفكار والعمل معاً لخدمة الإنسان وكوكب الأرض. نختتم الآن فعاليات اليوم. للمزيد عن فعالياتنا وبرامجنا في COP28 وما بعد هذا الحدث يرجى مسح ال QR كود المتوفر على الشاشات الإلكترونية في الجناح. شكراً ونراكم مجدداً وقريباً.